Kahn versus F Worldwide Corp, which apparently touches on Kahn versus Lynch communication system, which was set forth in Chapter 10. This case we're reading now is heard at the Supreme Court of Delaware in 2014 within the Freezeout merger transaction section of Chapter 14, Corporate Combinations, Tender Offers, and Defending Control. So starting off with the intro, that this suit was initiated on behalf of MFW stockholders against McAndrews and Forbes, challenging the pending merger of both firms that would result in McAndrews and Forbes acquiring at a substantial premium 57% of MFW that it did not own. McAndrews and Forbes promised that it would not pursue the transaction without the approval of an MFW special committee, which therefore had the power to say no. McAndrews and Forbes also stated it would not proceed without the approval by a majority of stockholders not affiliated with McAndrews and Forbes. This appeal presents a question of first impression. What should be the standard of review for a merger between a controlling stockholder and its subsidiary, where the merger is conditioned ab initio upon the approval of both an independent and adequately empowered special committee that fulfills its duty of care and the uncoerced informed vote of majority of the minority stockholders? The question has never been put directly to this court. The Court of Chancery held that the consequence should be that the business judgment standard of review will govern going private mergers with a controlling stockholder that are conditioned ab initio upon 1, the approval of an independent and fully empowered special committee that fulfills its duty of care, and 2, the uncoerced informed vote of the majority of the minority stockholders. So here's a business judgment standard review being proposed, requiring the special committee to fulfill the duty of care and the uncoerced informed vote of the minority stockholders. Does this take much time getting through this? Like 4 pages. Business judgment review standard adopted. We hold that business judgment is the standard of review that should govern mergers between a controlling stockholder and its corporate subsidiary, where the merger is conditioned ab initio upon both the approval of an independent, adequately empowered special committee that fulfills its duty of care and an uncoerced informed vote of a majority of the minority stockholders. We so conclude for several reasons. This is kind of important analysis. I'm just going to mark this page in a sticky. Did I just read that? First, entire fairness is the highest standard of review in corporate law. It is applied in the controller merger context as a substitute for the dual statutory protections of disinterested board and stockholder approval, both because protections are potentially undermined by the influence of the controller. However, where the controller irrevocably and publicly disables itself from using its control to dictate the outcome, this is kind of like the holding from the last case, which I expected, and it's cited right here on the next page. Where the controller irrevocably and publicly disables itself from using its control to dictate the outcome of the negotiations and the shareholder vote, the controlled merger then acquires the shareholder protective characteristics of third-party arm's length mergers, which are reviewed under the business judgment standard. Second, the dual procedural protections merger structure optimally protects the majority stockholders in controller buyouts. As the Court of Chancery explained, when these two protections are established up front, a potent tool to extract good value for the minority is established. From inception, the controlling stockholder knows that it cannot bypass the special committee's ability to say no. And the controlling stockholder knows it cannot de-angle a majority of the minority vote before the special committee late in the process as a deal closer rather than having to make a price move. Third, and as the Court of Chancery reasoned, applying the business judgment standard to the dual protection merger structure is consistent with the central tradition of Delaware law, which defers to the informed decisions of impartial directors, especially when those decisions have been approved by the disinterested stockholders on full information and without coercion. It will provide a strong incentive for controlling stockholders to accord minority investors in transactional structure that respected scholars believe will provide them with best protection, a structure where stockholders get the benefits of independent empowered negotiating agents to bargain for the best price and say no if the agents believe the deal is not advisable. For any proper reason, plus the critical ability to determine for themselves whether to accept any deal that their negotiating agents recommend to them. A transactional structure with both these protections is fundamentally different from one with only one protection. Fourth, the underlying purposes of the dual protection merger structure. Utilized here and the entire fairness standard of review both converge and are fulfilled at the same critical point, price. Following Weinberger versus UOP Inc., this court has consistently held that although entire fairness review compromises the dual components of fair dealing and entire fairness review, although entire fairness review comprises the dual components of fair dealing and fair price in a non-fraudulent transaction, price may be the preponderant consideration outweighing other features of the merger. The dual protection merger structure requires two price-related pretrial determinations. First, that a fair price was achieved by an empowered independent committee that acted with care, and second, that a fully informed, uncoerced majority of the minority stockholders voted in favor of the price that was recommended by the independent committee. The new standard summarized. To summarize our holding, in controller buyouts, the business judgment standard of review will be applied if and only if 1. The controller conditions the procession of the transaction on the approval of both the special committee and the majority of the minority stockholders. 2. And the special committee is independent. 3. The special committee is empowered to freely select its own advisors and to say no definitely. Okay. The new standard summarized. Where are we talking about? No in Romanet 3. Romanet 4, the special committee meets its duty of care in negotiating a fair price. And Romanet 5, the vote of the minority is informed. And Romanet 6, there is no coercion of the minority. If a plaintiff that can plead a reasonably conceivable set of facts showing that any or all of those enumerated conditions did not exist, that complaint would state a claim for relief that would entitle the plaintiff to proceed and conduct discovery. If, after discovery, triable issues of fact remain about whether either or both of the dual procedural protections were established, or if established were effective, the case will proceed to trial, in which the court will conduct an entire fairness review. So that paragraph, I'm my God, summarizing as preliminary, and that's not even the right word I wanted to use. Oh my God, thinking about the word I wanted to use while writing the word that I just thought about I wanted to use just made me forget the first word that I wanted to use. Oh my God. I wrote preliminary pleadings and procedure. That is not the word I wanted to use to summarize that paragraph. I don't care anymore. Dual protection inquiry. To reiterate, in this case, the controlling stockholder conditioned its offer upon the MFW board agreeing ab initio to both procedural protections, for example, approval by a special committee and by a majority of the minority shareholders, for the combination of an effective committee process, the majority of the minority vote to qualify jointly for business judgment review. Each of these protections must be effective singly to warrant a burden shift. As we have previously noted, deciding whether an independent committee was effective in negotiating price is a process so fact-intensive and inextricably intertwined with the merits of the entire fairness review, fair dealing, and fair price that a pretrial determination of burden shifting is often impossible. Here, however, the defendants have successfully established a record of independent committee effectiveness and process that warranted a grant of summary judgment entitled them to a burden shift prior to trial. So, I guess that was what the trial court or chancellor arrived at in the procedural history. So the court reviewed the challenges to the special committee members' independence, although each had some prior financial, professional, and social connections with either MFW's dominant stockholder, Perelman, or Perlman-related industry entities. The various dealings and interactions were not to raise to the level of being material. The court reasoned a plaintiff seeking to show that a director was not independent must satisfy a materiality standard. The court must conclude that the director in question has ties to the person whose proposal or actions he or she is evaluating that are sufficiently substantial that he or she could not objectively discharge his or her fiduciary duties. Consistent with that predicate materiality requirement, the existence of some financial ties between the interested party and the director without more is not disqualifying. The inquiry must be whether, applying the subjective standard, those ties were material in the sense that the alleged ties could have affected the impartiality of the individual director. The plaintiffs introduced evidence of various business relationships the committee members had over the years with Perlman and related businesses. The Court of Chanceries found that the earlier dealings between individual committee members and Perlman or entities related to him either did not involve amounts shown to be significant to a particular committee member or had occurred many years earlier, so that materiality today was not established. The Supreme Court held that the Court of Chancery's holding that the special committee members were independent was supported by the record. In holding that the committee was duly empowered, the court observed, the Court of Chancery also found that it was undisputed that the special committee was empowered, not simply to evaluate the offer like some special committees with weak mandates, but to negotiate with M&F over the terms of its offer to buy out the non-controlling stockholders. This negotiating power was accompanied by the clear authority to say no definitively to M&F and to make that decision stick. McAndrews and Forbes promised that it would not proceed with any going private proposal that did not have the support of the special committee. Therefore, the Court of Chancery concluded that MFW committee did not have a fear that if it bargained too hard, McAndrews and Forbes could bypass the committee and make a tender offer directly to the minority shareholders. The Supreme Court found further support for the committee being duly empowered and independent. Its rejection of the initially tendered price of $24 per share by demanding $30. However, once the committee learned of MFW's deteriorating financial position, it ultimately supported a buyout price of $25. In doing so, the committee met 8 times, was advised by its own counsel and investment banker. The Supreme Court viewed these efforts supporting the conclusion the committee exercised due care. Finding that 65% of the minority shares approved the acquisition and that proxy materials fully disclose all facts, including the earlier committee $30 counteroffer, as well as internal estimates available to the committee, supported a finding that the majority of the minority vote was fully informed and uncoerced. Business judgment review properly applied. We have determined that the business judgment rule standard of review applies to this controlling stockholder buyout. In this case, it cannot be credibly argued, let alone concluded, that no rational person would find the merger favorable to MFW's minority shareholders. For the above stated reasons, the judgment of the Court of Chancery is affirmed. So note on the purpose test, which you saw in the earlier cases just read, Weinberger versus UOP, that the Supreme Court of Delaware wanted to get away from it because they expanded the court's discretion and didn't feel it a necessary inquiry. We're going to talk about that at this point in the notes to these 2 cases. So while Delaware subjects the transactions to scrutiny under the entire fairness standard, some courts examine the purpose surrounding the cash-out merger. For example, Coggins versus New England Patriots football club, Inc., in Massachusetts, 1986, involved the freezeout of the non-voting common shareholders by Michael H. Sullivan Jr., who had recently acquired all of the voting common for the New England Patriots using money borrowed from 2 banks. The bank's loans required him to pledge voting shares as collateral for the loan and use his best efforts to reorganize the Patriots so that its income could be devoted to the repayment of Sullivan's personal loans. Unlike the Delaware court, we believe that the business purpose test is an additional useful means under our statutes and case law for examining a transaction in which a controlling stockholder eliminates the minority interest in a corporation. A controlling stockholder who is a director standing on both sides of the transaction bears the burden of showing that the transaction does not violate fiduciary obligations. Remember that rule. And judicial scrutiny should begin with recognition of the basic principle that the duty of a corporate director must be to further the legitimate goals of the corporation, not just repay personal debt. So I'll just write that here, not just to repay, personal loan. The plaintiffs here adequately allege that the merger of the old Patriots and the new Patriots was a freeze-out merger undertaken for no legitimate purpose, but merely for the personal benefit of Sullivan. While we recognize the right to selfish ownership in a corporation, such a right must be balanced against the concept of the majority shareholders' fiduciary obligation to the minority shareholders. Wilkes versus Springside Nursing Home, a Massachusetts case. Consequently, the defendants bear the burden of proving that the merger was for a legitimate business purpose, and second, that considering the totality of the circumstances, it was fair to the minority. And the decision of the Superior Court judge includes a finding that the defendants have failed to demonstrate that the merger served any valid objective unrelated to the personal interests of the majority shareholders. It thus appears that the sole reason for the merger was to effectuate a restructuring of the Patriots that would enable the repayment of a personal indebtedness incurred by Sullivan. And the court declared the merger freeze-out invalid and remanded the case to award rescission damages to the objecting minority shareholders based on the then current value of the company. I don't really agree with this opinion, but New York similarly requires proof of business purpose. So this is Massachusetts basically rescinding perfectly acceptable business. And then New York is right on over here. Let's read about this nonsense. In the context of a Freezeout merger, variant treatment of the minority shareholders, i.e. causing their removal, will be justified when related to the advancement of a general corporate interest. This is absurd. The benefit need not be great, but it must be for the corporation. So, like, that's their position there. Massachusetts, how they kind of put it. And they said something about selfish ownership. While we recognize the right to selfish ownership in a corporation, at least they're saying there should be a balance against fiduciary obligations to the minority. Not just that there like has to be one. I'm just going to call that reasoning. This is Massachusetts reasoning, right? And the way over it is that you recognize your duties to the minority. Here, New York is just saying there need not be a big benefit to the corporation, but there must be a benefit to the corporation. Don't tell me that then you can't buy out a company's minority shareholders for yourself without more. For example, if the sole purpose of the merger is reduction of the number of profit sharers in contrast to increasing the corporation's capital or profits or improving the management structure, there will exist no independent corporate interest. From Schwartz versus Marion, don't know the date. All of these purposes ultimately seek to increase the individual wealth of the remaining shareholders. What distinguishes a proper corporate purpose from an improper one is that with the former, removal of the minority shareholders furthers the objective of conferring some general gain upon the corporation. Only then will the fiduciary duty of good and prudent management of the corporation serve to override the concurrent duty to treat all shareholders fairly. We further note that a finding that there was an independent corporate purpose for the action taken by the majority will not be defeated merely by the fact the corporate objective could have been accomplished in another way, or by the fact that the action chosen was not the best way to achieve the bona fide business objective. That citation came from Alpert versus Williams Street Corp of New York, 1984, finding the requisite purpose was established by evidence that additional capital needed to repair the company's property was not available so long as the minority interest was outstanding. And I think that was a good enough reason, even though it wasn't like the only way to get the money for the improvements, is what was just said there. So, Glassman versus Unical Exploration Corporation is the next case. It's not so long that I can't get through it. Same with the next case. So maybe I'll keep reading. Berger gave this opinion in the Supreme Court of Delaware and Bank in 2001. In this appeal, we consider the fiduciary duties owed by a parent corporation to the subsidiaries' minority stockholders in the context of a short-form merger. Specifically, we take this opportunity to reconcile a fiduciary's seemingly absolute duty to establish the entire fairness of any self-dealing transaction with the less demanding requirements of the short-form merger statute. The statute authorizes the elimination of minority stockholders by a summary process that does not involve the fair dealing component of entire fairness. Indeed, the statute does not contemplate any dealing at all. Thus, a parent corporation cannot satisfy the entire fairness standard if it follows the terms of a short-form merger statute without more. So they're trying to reconcile a fiduciary's seamless absolute duty to establish entire fairness of any self-dealing transaction with the less demanding requirements of the short form merger statute, which is currently at odds. Unical Corporation addressed this dilemma by establishing a special negotiating committee, and that's the material fact, right? And then engaging in a process that it believed would pass muster under traditional entire fairness review. We find that such steps were unnecessary. One material effect. Two, which I don't know how they did that, but nonetheless, Part 1, factual and procedural background. Unical Corporation owned approximately 96% of the stock of Unical Exploration. In December 1991, the boards of each company appointed special committees to consider a possible merger. The Exploration Special Committee retained financial and legal advisors, met 4 times, and agreed to the merger exchange ratio where 0.54 Unical shares would be issued for each UXC share, which is Exploration ticker, whatever ticker symbol. They announced their agreement on February 24th, 1982, and carried it out pursuant to Delaware's short form merger provision in Section 253 of Title 8 of Delaware law on May 2nd of 1982. The plaintiffs then filed an action on behalf of UXC, the exploration company, minority shareholders, alleging the merger violated Weinberg's entire fairness requirement. The discussion follows a short-form merger statute as enacted in 1937, authorized the parent corporation to merge with its wholly owned subsidiary by filing and recording a certificate evidencing the parent's ownership and its merger resolution. In 1957, the statute was expanded to include parent-subsidiary mergers where the parent company owns at least 90%, that's right, of the stock of the subsidiary. The 1957 amendment also made it possible for the first time, and only in a short-form merger, to pay the minority cash for their shares, thereby eliminating their ownership interest in the company. We must decide whether a minority stockholder may challenge a short-form merger by seeking equitable relief through an entire fairness claim. Basically, that's the issue. Under settled principles, the parent corporation and its directors undertaking a short-form merger are self-dealing fiduciaries who should be required to establish entire fairness, including fair dealing and fair price. Technically, according to the case law we read, and they cite it here as Weinberger, right? And the problem is that Section 253 authorizes a summary procedure that is inconsistent with the reasonable notion of fair dealing. In a short-form merger, there is no agreement of merger negotiated by two companies. There is only a unilateral act, a decision by the parent company that its 90% owned subsidiary shall no longer exist as a separate entity. And that's like practically a restatement of the rule. So I'm going to write rule in the merger here because that's literally what the rule is requiring, which is not entire fairness is the point, which you would only know in the earlier recording where I defined short form merger. So the minority stockholders receive no advance notice. That's right. Minority gets no advance notice of the merger. Their directors do not consider or approve it, and there is no vote because they're already 90% owned. Those who object are given the right to obtain fair value for their shares through an appraisal. So they do get the appraisal right. That's exactly what it is. And the equitable claim plainly conflicts with the statute. If a corporate fiduciary, so the cause of action that they're bringing for entire fairness, conflicts plainly with the statute. If a corporate fiduciary follows a truncated process authorized in 253, it will not be able to establish the fair dealing prong of entire fairness. If instead the corporate fiduciary sets up negotiating committees, hires independent counsel and legal experts, etc., then it will have lost the very benefit provided by the statute, a simple, fast, and inexpensive process for accomplishing a merger. We resolve this conflict by giving effect the intent of the General Assembly. In order to serve its purpose, 253 must be construed to obviate the requirement to establish entire fairness. Thus, we hold that, absent fraud or illegality, appraisal is the exclusive remedy available to minority stockholders who objects to a short form merger. In doing so, we also reaffirm Weinberger's statements about the scope of appraisal. The determination of fair value must be based on all relevant factors, including damages and elements to future value, where appropriate. So, for example, if the merger was timed to take advantage of a depressed market or a low point in the company's cyclical earnings, or to precede an anticipated positive development, we recognize that these are the types of issues frequently raised in entire fairness claims, and we have held that claims for unfair dealing cannot be litigated in an appraisal. But our prior holdings simply explain that equitable claims may not be engrafted onto a statutory appraisal proceeding. Stockholders may not receive rescissionary relief in an appraisal. Those decisions should not be read to restrict the elements of value that properly may be considered in an appraisal. Although fiduciaries are not required to establish entire fairness in a short-form merger, the duty of full disclosure remains. In the context of this request for stockholder action, where the only choice for the minority stockholders is whether to accept the merger consideration or seek appraisal, they must be given all the factual information that is material to that decision. The Court of Chancery carefully considered plaintiff's disclosure claims and applied settled law in rejecting them. We affirm this aspect of the appeal on the basis of the trial court's decision. So the conclusion, based on the following, we affirm the Court of Chancery and hold that the plaintiff's only remedy in connection with the short form merger of UXC into Unical was appraisal. Solomon versus Path, Credit Lyonnais Bank Nederland, NVCLBN is the ticker, pursuant to a loan agreement with Path Communications Corporation, controlled 89.5% of Path's voting stock. In response to CLBN's offer to make a tender offer for Path shares, Path created a special committee and supported CLBN's tender offer to acquire 5.8 million Path shares at $1.50 per share. John Solomon instituted a class action on behalf of the Path minority shareholders, alleging the tender offer was unfair, coercive, and was a breach of the CLBN's duty of loyalty as a controlling shareholder, and that Path board had acted improperly by failing to obtain independent advisors to assess the tender offer. The complaint attempts to assert a breach of duty of fair dealing by the directors because they did not oppose the tender offer. The asserted unfairness of the tender offer is based on an allegedly inadequate price. And the Chancellor's holding that none of the facts cited by Solomon can be said to arouse as much as a fleeting doubt of the fairness of the disclosure or the 150 tender offer price is correct as a matter of law. In the case of totally voluntary tender offers, and this again is heard by the Supreme Court of Delaware in 1996, which is before the new sort of business judgment review came about in 2014, like FYI. So in the case of totally voluntary tender offers, as here, courts do not impose any right of the shareholders to receive a particular price. Delaware law recognizes that as to allegedly voluntary tender offers, in contrast to cash-out mergers, the determinative factor as to materially false or misleading disclosures made to shareholders in connection with the offer, Eisenberg v. Chicago Milwaukee Corp., In 1987, citations omitted, a transaction may be considered involuntary despite being voluntary in appearance and form if one of these factors is present. There was no well-pled allegation of any coercion of false or misleading disclosures in the present case. However, period. So the pleadings, I mean, like reading the cause of action again was talking about a breach of duty of loyalty. The court kind of gave, failure to obtain the best price or attain independent advisors to inform on the best price. And the court then kind of gave additional words to it by saying a duty of fair dealing. But what is being said here is that the pleading requirement is there to be some type of like bad faith, in short, which would be materially false or misleading disclosures. So the pleading was insufficient. Moreover, in the absence of coercion or disclosure violations, the adequacy of the price in a voluntary tender offer cannot be an issue. In the absence of coercion and disclosure violations. And that's from case law. So that's kind of the analysis. Solomon has pled no facts from which there could be drawn a reasonable inference that there was coercion or lack of complete disclosure. The amended complaint focuses mainly on a conclusory allegation that coercion was present. The complaint, therefore, falls well short of the minimum notice requirements. Conclusions will not be accepted as true without specific allegations of fact to support them. I don't know where that comes from, but it would be good to know that. It's just like ... no footnotes. For the foregoing reasons, the Court of Chancery's dismissal of Solomon's claim under Rule 12b-6 for failure to state a claim upon which relief can be granted is affirmed. That's your conclusion. In re Pure Resources, Inc. and shareholder litigation, it's a little bit of a longer case to go through before we get to the next note section. So I'm just going to stop reading for a little while.